Welcome. Hello, everyone, and thank you very much for attending today's webinar, CCPA for Financial Institutions. I'm Jim Shreve. I'm chair of the cybersecurity practice at Thompson Coburn, and I have a great panel to discuss this topic today. Before we begin, we've got a few housekeeping items to discuss. If you have any questions during the webcast, you can submit them through the Q&A widget at the bottom of your screen. We'll try and answer those at the end of the webcast. There's a fuller answer that it's needed, or if we run out of time, we'll answer them later by email. A copy of the slide deck from today's presentation is available in the resource widget. The webinar will be recorded and should be available on the Thompson Coburn website within a day. You can find additional answers to some common technical questions located in the help widget at the bottom of the screen. This webinar is CLE accredited in California, Illinois, and Texas for 1.0 hours of general CLE credit, and in Missouri for 1.2 hours of general CLE credit. We reward CLE credit based on attendance for the entire 60 minutes. From time to time, you may see a pop-up on your screen that you have to click to reflect continued engagement. Your CLE certificate will be emailed to you later this afternoon once we've verified attendance. The widget at the bottom of the screen saying certificate will only show whether or not you have you have earned the certificate. We value your opinions and appreciate your participation in the course. CCPA, the California Consumer Privacy Act, is the biggest privacy topic in the U.S. over the last couple of years, with enforcement possibly beginning as early as July 1st, just around the corner. It remains front and center, even with so many other issues that are affecting all of us. As I mentioned, we have a great panel of experts with us today to discuss these issues under CCPA. And I'd like each of them to introduce themselves. First, Agnes, then Ron, Jerry, and then Luke.
Thank you. Good afternoon, and thanks for having me join you today. My name is Agnes Bundy Scanlan, and I'm president of the Cambridge Group, which is a regulatory risk management advisory firm. Thank you.
Good afternoon. This is Ron Whitworth. I'm the Chief Privacy Officer at Truist, which is the new combination of SunTrust and BB&T based out of Charlotte, North Carolina. Thank you for having me today.
Hi, everyone. I'm Jerry Spada. I'm with the Privacy Office at LPL Financial, a financial services firm, and I'm located in Fort Mill, South Carolina.
And hi, everybody, and thank you again for joining. My name is Luke Sosnicki. I am a litigator based in Thompson Coburn's Los Angeles office. I've been a litigator for 15 years, and I've focused 11 of those years on representing financial institutions in all sorts of consumer claims relating to lending, servicing, credit reporting, and as pertains to today, privacy issues, including the CCPA.
Excellent. Thank you all for your participation. Today's session is going to be in two parts. First, my colleague Luke and I are going to go over some of the key features of CCPA and some of the issues that impact financial institutions there. Then our panel are going to address a few questions about implementing CCPA, addressing some of the risks that it poses in balancing CCPA compliance with addressing some of those other issues that we're all facing. So with that in mind, I'll hand it over to Luke to go over some CCPA issues.
Thank you, Jim. So for those folks, as Jim said, this has been a prevalent front and center issue for in privacy law for quite a bit. But for those folks who might be a bit newer to the statute, we prepared just some basic overview of what the statute requires. So the statute was originally a ballot measure. It was passed in June 2018. It was thereafter amended a few times, most notably in October of 2019 to add a few exemptions that we're going to focus on today. The statute took effect earlier this year on January 1st, including, importantly, the private right of action that we're all going to talk about a little bit later today also took effect on January 1st. The enforcement begins July 1st. The regulations are not yet finalized. The enforcement is scheduled to begin in the absence of finalized regulations, but being that as it is, the enforcement is still scheduled to begin very shortly here. In terms of what the statute covers, the statute applies to a defined term of covered businesses. Just very briefly, a covered business is a business that does business in California, collects California consumers' information, and either has in excess of $25 million in revenue, collects more than 50,000 records, or derives more than 50% of its income from the sale of consumers' personal information. A consumer, for purposes of the statute, is basically a California resident, and personal information is very, very broadly defined to be information that identifies, relates to, describes, or is reasonably capable of being associated with, or could reasonably be linked directly or indirectly with a particular consumer or household. Obviously, a very broad definition. So what does the statute actually do? Well, it grants consumers certain rights with respect to the personal information that companies collect about them. That includes the right to know what information has been collected, the right to delete information, the right to opt out of the sale of personal information, the right to equal treatment, which basically means the right to receive the same treatment whether you permit companies to use your information or not, the right to be the right to security, which is basically the right to be secure from data breaches, the right to be free from having the information that companies collect about you be disseminated. And on the flip side, what does the statute require of the businesses? If you are a CCPA covered entity, there's a couple things that you, as of January 1st, need to do. You need to provide compliant notices to consumers, including very specific information that the statute requires what consumers now need to know, including the categories of information that you collect, what you do with it, and then certainly, as importantly, whether you sell it. You need to comply with various consumer requests relating to the information that you collect. You need to be able to comply with right to access requests, to be able to tell folks in a timely manner and specifically prescribed time frames what information you're collecting and produce it back to them if they so request. You need to maintain reasonable security procedures and practices, which basically means you need to implement procedures to keep the information that you're collecting safe, and on penalty of both Attorney General enforcement, again, as we'll discuss a little bit later today, private right of action specific to data breaches. And finally, you need to keep records of your compliance. You need to keep accurate records of the consumer requests that you're receiving. And again, as we'll discuss a little bit later today about the processes you've undertaken to comply with the CCPA, including training your employees. So again, that was I understand that was a very quick overview of the statute, and now we'll get into a little bit about how it applies to financial institutions. Jim?
Thanks very much, Luke. In response to a question that came in from Boston, yes, there are exceptions under CCPA. There are several of them. 3 of them primarily come into play for financial institutions. There is the so-called GLBA exception, an exemption that covers personal information obtained in the context of a business-to-business relationship, and the so-called employee exemption. Financial institutions are not themselves fully exempted from CCPA requirements, but much of the information that they possess, at least presently, is exempted from the CCPA requirements. That said, this complex web of exemptions creates some potential difficulties. The GLBA exemption, CCPA exempts from its coverage data that is subject to the protections of GLBA, not institutions, as would typically be the case in statutory exemptions. So it's led many financial institutions to examine more closely what data they have is covered by GLBA. So, for example, they're looking at business accounts. Just as an example, let's say you have somebody who is a sole proprietor of a business, and they come into a bank on Monday and obtain a personal loan. That's covered by GLBA. They're going to get a GLBA privacy notice. And so that information in regard to that loan would be probably then appears within the CCPA exemption. Same person comes in on Tuesday and obtains a business loan and for their sole proprietorship. That's a business product not subject to GLBA, and so it's less likely to be within that exemption under CCPA. And there are other areas where financial institutions are looking at trusts or quasi-trust type arrangements, like with minors accounts. Whether or not those are subject to GLBA or may have more CCPA rights, as well as prospects and leads that have not reached out affirmatively to the financial institution. That may fall outside of GLBA and be more subject to CCPA. Business-to-business exemption. The language of that exemption has led to some confusion about what is covered. I would urge you to read it very carefully. But I would also note that to the extent you're requiring on that exemption for business-to-business arrangements, right now that's scheduled to expire in 2021. That was an amendment to CCPA put in after the original law was enacted. If we enact the CPRA, as we'll talk about a little bit later, or other legislation that could extend that exemption, but right now it's scheduled to expire next year. Employee exemption. It's broader than just employees. It covers contractors, job applicants, many others. It covers many that would be otherwise outside of GLBA for a financial institution. I would also note that exemption is scheduled to expire in the next year unless something changes as well. And so here on this next slide, note a few situations where there may be confusion as to whether or not particular information is exempt from CCPA or not. This gets to be very complex. And I certainly think this is something you should be looking at. Consider, I think it's a very fact-specific determination. And I think that reasonable minds can differ quite often as to whether or not something is exempted from CCPA or not. Ultimately, unfortunately, we may not know until we have enforcement actions as to what is within or without. There's also the issue of disparate treatment. If you determine that some individuals have CCPA rights and others don't, are you going to treat those individuals differently and apply CCPA only where it statutorily applies? So with that, very brief overview, I'd like to get into the panel discussion. And so we're going to go into a few of these issues. I'd like to lead off with a question. What are some of the issues you've seen in preparing for CCPA? And I'd like to direct that first to our two in-house people. Jerry, would you mind leading us off?
Sure, thanks, Jim. So some of the issues that folks internally have had to address have to do with the kind of things you'd expect just starting off on a project that involves personal information. So what personal information do we have? Where does it sit? What systems does it flow through? Who owns that data? Who's empowered to make decisions about that data? Do we Do we just focus our efforts on California data, since it's California resident data, or do we focus our efforts more generally around the way data flows through our systems? And given the prevalence of California data, is there a difference? How do you get, what do you think your efforts need to be? How do you get funding for that? How do you align technology and the business owners? Those are who's going to manage your project. Things like that are all issues that one faces at the threshold when trying to interpret and then a statute like CCPA and then implement and address the issues that arise there. Ron?
Yeah, Jerry, we definitely had those considerations as well. You covered that very well. I think, initially a lot of thinking had to go into the approach here. It's interesting as you go across different financial institutions, everybody's handling this a little bit differently based on their, particular situation. But I think it starts with some of the things that you talked about. I mean, first of all, what data do you have? As Jim mentioned, just figuring out what data are you collecting? Does it fall within the exemption? And then, of course, are you going to treat all consumers the same, or just go through this exercise initially for California? And then, things like how are you going to authenticate requests? What is your client experience going to be like? So if somebody's coming and making a request for your company, what is the approach? Are you using an in-house system or maybe a third-party system that you would onboard for this purpose? And what is that client experience going to feel like? For example, if you're one of those financial institutions that is limiting it to California, how are you going to treat those requests that come in from outside of California? What are you going to tell those consumers, and how do you kind of deal with those requests? I think just those are some of the foundational questions that we've all had to grapple with, and like I mentioned, a lot of folks are handling it very differently throughout the industry. There's not really a one-size-fits-all solution to this.
Do our other panelists want to offer any thoughts on this question?
I think they covered it well.
Okay, thank you. All right, so I think we can move on to the next question. So, as we noted, from July 1st, potentially the California AG's office could begin to bring enforcement actions under CCPA. Although there's some question as to timing as to when the rules themselves may be enforceable. So as they're looking out and looking at compliance with CCPA and thinking about where to put their limited resources, the AG's office has said, okay, we can't go after everyone who might violate CCPA. We're somewhat limited in what we can do. What are some of the considerations they may take into account when determining whether to bring an enforcement action? And I would certainly welcome the thoughts of Agnes Bundy Scanlan about this, having been at a regulator who brings enforcement actions.
Sure. So I will put on my regulator hat for this response. And just as a context, I recently sat in on a bank's examination meeting, and while the topic of that examination doesn't matter, some of the regulators' comments are relevant here as we think about overall Compliance 101. So broadly speaking, the need to consistently follow your documented standards. Do what you say you're going to do. Your plan for compliance for CCPA should be documented enough to obviously be effective. And then as you go along, as you move along with your implementation, monitor and test your implementations. Now, if we look at this specifically as to where banks might get into trouble and where there might be some violations of CCPA, from California. Quite frankly, a lot of this is common sense, but here are some thoughts. You might be in violation if you're not informing the consumers of their rights. So as you know, it is a CCPA violation if the internal or enterprise stakeholders responsible for handling consumer requests don't understand the actual provisions and can't direct the consumers to make inquiries. Note the theme, the major theme of CCPA. It's really dealing with consumers' rights, how the handling of California consumers' data is ethically and lawfully handled. So internally, CCPA stakeholders really have to understand the definition of personal data and know that it's a broad definition. Another area of possible violation is not enabling the disclosure request. So if a bank violates CCPA, if it does not provide, it will violate if it doesn't provide a toll-free number, if it doesn't provide a website address for consumers to make disclosure requests. Those are areas of violation, and they're pretty much the minimum standard as a way for allowing consumers to contact you with their requests. Now, I have been understanding, and this might be something to talk about again later, but there haven't been as many requests coming into financial institutions as well as for other institutions, but this is a basics of CCPA. And I remember years ago with another privacy new regulation that it was summertime and the FTC hired a lot of college students to literally look at companies' websites and analyze them for their privacy policies with various compliance. Well, this is a perfect summer to do that with all of the COVID lack of hiring and canceling many plans. Both college students as well as others are probably being hired by some regulator or two or three to look at the policies and look at websites and see how people are complying. A third area is discriminating against consumers. So a business shall not discriminate against consumers who exercise their rights for CCPA. So when you think about this, the discrimination could include refusing their business, include charging different prices or providing a different level of services or goods. So there can't even be any suggestion by the business to a consumer that any of these things could even occur if they exercise their CCPA rights. Another area is not providing consumer information in the correct way. It is a violation of CCPA if you provide personal information requested by a consumer in a way that's not portable and to the extent technically feasible. So again, we've got a sort of conspicuousness that needs to be handled here. And then another area, and sort of last, is not updating the privacy policies and websites. That goes back to the potential college students looking at websites this summer to double, triple check them. A business must disclose in the privacy policies or whatever kind of description of California specific rights, the information required by CCPA, and then further, afterwards, it has to update such a policy or document every 12 months. So basically, you have to have some sort of a privacy incident procedure document, or again, whatever you might want to call it, and there must be documented procedures to follow. Note that your internal auditors, your external regulators, if you have a third party assisting, they're going to require attestation as to whether or not such documentation is in place. So those are some initial areas that I think might be of concern and might tip the point with possible enforcement.
Excellent, Agnes. Luke, do you have any thoughts as a litigator?
Yeah, I'd like to pick up on, first of all, I absolutely agree with everything that Agnes said, and I'd like to pick up on two of those points. I think her point about training, I mean, I cannot overemphasize how important that is, and certainly within the CCPA context as well. You know, this is something that Jim mentioned as well. The Attorney General's resources are not infinite, and they've publicly stated that their capacity to bring enforcement actions is not huge. And while they haven't been terribly forthcoming about what they intend to focus on or what specific issues they're looking at, one of the things they've hinted at is that they're going to look at consumer complaints, again, not surprisingly, as an avenue of finding out what companies are actually doing wrong. You know, in addition to investigating the issues themselves, they're simply going to look at what complaints are coming in and let that drive what they look to. And I think that it's a good idea for companies to do the same thing, and that certainly starts with, as Agnes said, with training your stakeholders internally to understand what their obligations are, and then training the same folks externally to deal with your customers, to frame their interactions and to accurately track complaints. If you want to get an idea of what you might get investigated about, it's probably a good idea to check internally what your customers are complaining about, because there's a good chance that those same customers are going to make same or similar complaints to the AG. And the AG has, again, publicly stated that that's an avenue that they're going to pick up ideas for enforcement. So that's very important. The other thing that I think I want to say is that the AG has now been asked by numerous trade organizations in various different ways to postpone the deadline or postpone the start date for enforcement. And while the AG has steadfastly maintained that it won't, I think the famous quote was that privacy doesn't wait or something along those lines. The AG is also not deaf to some of the concerns that companies have raised. The AG understands that this was a hastily drafted statute in many ways, that given its history as a ballot initiative that was then picked up very quickly by the legislature and kind of patchwork amended. And then the separate issue of the regulations not even being finalized on the enforcement date, potentially. The regulations have undergone a series of revisions as well, and those too were very hastily drafted, and there's a lot of ambiguity left. And again, I mean, even though the AG has publicly said that none of those are terribly good reasons to delay enforcement to next year, which a lot of folks have asked for, I think there is a general expectation, or if not expectation, at least hope, that the AG is going to take those issues into account. So when considering what types of enforcement actions they might consider and bring, I think this goes back to another point, really important point that Agnes raised, which is the AG is going to look for very good efforts, solid efforts at compliance, which means things like documenting what you're doing, documenting your policies. As Agnes said, make sure you can comply with what you've documented, but make sure to be in a position where you can present to the regulators that you're doing your best to comply. And again, there might be ambiguities, there might be things that are going to be worked out through the courts or through enforcement actions in terms of what they actually mean, but that doesn't excuse solid efforts to get your programs together, get your data maps together, understand what you have, and do everything you can to comply.
Yeah, I think those are all excellent points. Thanks, Agnes and Luke. I think, you know, coming from a regulatory background myself, it's important to have a good story to tell. Even if you can't be 100% compliant with CCPA after July 1, have a good story to tell, be able to document what you have done, and if there's some things you haven't been able to put into place, if you have a good explanation for why, that helps, that mitigates things. Because early on, the AG's office having these limited resources, I have to think, if you have potentially a number of enforcement actions you could take, why not go after the easy one? Why not go after some entity who clearly should know better and has done little to nothing to comply, rather than someone who clearly has attempted to do their best to come into compliance. So with that, let's move on to the next question. So for our in-house people here, what are some of the issues you've seen in how to benchmark CCPA compliance, how to measure your compliance with these new requirements? Ron?
Sure. So, I would start off by saying that, this exercise leading up to CCPA has lent itself to one of the most extensive benchmarking experiences that I've had in my privacy career. I mean, we are, really in constant contact with our peer banks and others through the Bank Policy Institute and other forums, and really have been for well over a year. And I think it kind of speaks to the complexity of this law and the nuances that are very difficult. As Luke mentioned, that the regulations aren't even finalized. So, a lot of companies have been grappling with, how are you handling certain components of this, and how are you interpreting different provisions of CCPA? And we've seen a lot of attempts really in the industry to stack hands with one another, where let's try to come up with some common interpretations or common approaches. There was even a push at one point to have a GLBA model form like notice, so everybody's CCPA notice would look and feel exactly the same, the way that the GLBA model form does. So, this is really an area where the banks have really stacked hands. There's a lot of communication that has gone on, and I think it's one of these strength in numbers type deals where nobody is entirely certain where this is going to shake out and exactly how it's going to be interpreted and enforced. But I think everybody's really trying to do the right thing, first of all, and nobody's trying to skirt this issue. Everybody's trying to do the right thing. They're trying to comply. They're trying to do what is right for consumers, but they're also really just trying to understand what everybody else is doing and trying to make sure that nobody is an outlier in this situation. And Jerry, I know you've had a number of these benchmarking conversations in different forms as well.
Yes. Thanks, Ron. That was a really comprehensive view, right, across the end perspective on benchmarking and the extent of it, as we all grapple with as Jim said, a kind of a statute that was hastily drafted and then changed right up until a couple of months before the initial effective date, and then the regulations kind of having 3 or 4 iterations and still not being final, right? So what did we do? Well, in more of the broker-dealer kind of space rather than the bank kind of space, there's a SIFMA data privacy and security working group. It used to be a committee, a SIFMA committee or a subcommittee of the Tech Governance Committee, but now it's a working group, and that was a really fruitful forum to share with various privacy departments what they're doing, how they're thinking about issues, how they're approaching things in terms of what to do and when, giving the kind of shifting deadlines. And I know one of the consultancies, Promontory, has a group that meets like kind of quarterly. Again, they do surveys and they kind of benchmark where folks are against each other and what people are grappling with and the like. And calling other consultancies that you can think of where they've got folks in this space is really helpful, as they can see, across the street what different people are doing. Talking to your peer institutions beyond the larger committees, folks who are more like you in your corner of the financial services space, and what they're doing and how they're approaching things, because this effort comes with a whole bunch of T intersections, if you will, or forks in the road, and you've got to make decisions, a whole bunch of them, without a heck of a lot of guidance, and hoping that folks looking at you 2020 with 2020 hindsight are going to be looking favorably upon you. And it helps to see how other people are thinking through issues quite similar to yours. And then finally, last but certainly not least, folks like Jim and Luke, right, who are grappling with the really most difficult questions, the most difficult T intersections to navigate in this space, and how they're seeing other people handle them and how they're thinking about them. All of those things combined give you the ballast, maybe that's the wrong word, but to do what you need to do to make those decisions at the T intersections, to keep advancing and then adjusting as best you can as circumstances evolve.
And don't you think, Ron and Jerry, that there's a feeling of we're all in this together, and there really is a lot of sharing of information in all of those forums. It seems as though people are really transparent with key issues, and everyone's trying to find solutions together in so much uncertainty.
Yeah, absolutely. There are really no state secrets in this area. You were talking to your competitors, but this is not a space that we're really competing over. It does have that feel of we're all in this together. And at the end of the day, everybody really is trying to do the right thing. I mean, we've had situations where you have a lot of banks in the same room together, and everybody is very passionately trying to figure out how to do this correctly. And it's really not just about the compliance aspect either. I think that the banks and other financial institutions have heard the call here. They understand where this is coming from and that this is important to consumers. So if it's important to consumers, it's important to all of our clients, and therefore it's in everybody's best interest to really dive in and do this the right way. And I think we've seen that a lot in the industry. And the other thing I would just say is that if there's anybody on the call that feels like you're not sure where to start and you don't have that type of network, don't be shy about reaching out to those of us on this call or others in the IAPP community, because what I've found is this community is very, very helpful. It's a lot of people are willing to help peers and willing to help new folks in the industry. And I have yet to come across somebody who has said, "Sorry, I don't have time to talk to you. I don't have time to compare notes." It's really a community that is incredibly helpful, and don't be shy in terms of reaching out.
Yeah, if I could, I'd like to echo what Ron. Oh, sorry, Jim.
No, go ahead. Go ahead, Jerry.
Definitely echo what Ron said about the willingness of folks to share, and because there really aren't. There's nobody who takes a proprietary view of these efforts, right? We're all trying to figure it out, and frankly, if we're all stronger together in this as we figure it out and protect, consumer, customer information. And certainly Agnes has been, a great voice in this industry for decades, and her perspective from a regulator's lens is really helpful to make sure that you're not just thinking that you have good faith efforts, but that what you're doing and your breadcrumb trail of how you're documenting things gives regulators that view as well.
Yes, well, thank you all, and I would wholeheartedly agree that this space is remarkably collegial, and there are a lot of people who are willing to help out on these issues. Maybe we can move on to the next question. So. Currently, all of us are dealing with CCPA, trying to get into compliance, but we're not doing this in a vacuum. And so, I don't need to tell anyone that there's a lot going on out there right now. And so the question comes up, how do you balance CCPA risks and compliance, preparing for that with many of the other risks and issues that your enterprise may be facing, particularly with COVID-19? And I think I'd maybe first go to Agnes as someone who's been in-house in a position where you had to where you're in charge of privacy compliance and many other compliance areas, and how to balance risks that at times may be competing for resources.
Sure, Jim, and you mentioned a couple right at the start. So for this response, I'm putting on my Chief Compliance Officer and CPO hats that I used to wear, and I'll think about this from the perspective of the overall risk to the enterprise with COVID on the horizon. So many of the regulatory risks that have been further impacted by the pandemic and the economic recovery do relate to CARES Act and PPP and all of those. And those risks really include overall strategy. What's the strategy considering everything going on? The actual application processing, underwriting, servicing, loan forgiveness now, and Jim, you had mentioned disparate treatment, so fair lending and complying with CRA and unfair and deceptive abusive acts and practices, UDAP, fraud and money laundering, and all of those types of issues, and probably a whole host more, really collide and are interspersed with the pandemic and the risks that face the institutions. Many of you and your colleagues have had to review lender decisions and performance during the academic or the application processing and servicing and forgiveness. So you're balancing business as usual. You're looking at the pandemic. You're looking at the overall economic reaction to the pandemic on your institution and personally also. And then there's also the transition to what's the new norm or what's coming next. So again, we go back to hopefully you've been documenting all of your actions relating to CCPA and compliance also with the CARES Act and PPP. And during the regular meetings and other compliance meetings with regulators, we know that the regulators have asked the bankers, how have you been doing in compliance with CARES Act? And I don't know about you all, but I got a notice right before this call from the Federal Reserve, which says June 23rd, federal and state regulatory agencies issue examiner guidance for assessing safety and soundness considering the effect of COVID-19 pandemic on financial institutions. And it has the Fed, the OCC, the FDIC, credit union, state regulators. Of course, my former regulator, the CFPB, is not on here. But this just goes to show that notwithstanding what's going on from a broad-based perspective with the society and with COVID, you still need to have business as usual. But if we break this down and look specifically with CCPA and privacy, there's that balance, too, of health versus privacy. So on top of having uncertain regulations and the impact of the virus, people are going back to work. So I'm just going to mention a couple of specifically privacy issues that the California AG may be watching. And so one of them, obviously, is that it's watching the virus and how the virus might have changed in terms of your security and privacy compliance. Because now, as we all know, many employees are using their own IT infrastructure. And that's not something that was necessarily planned, certainly not the number of people who are doing it. So when you think about it and you think about the number of people working from home and how it's jumped to all-time high levels, not many were ready for this sort of full-fledged remote working. So consequently, again, many protections weren't in place. So to protect the employees, workplaces and customers and operations, many companies have taken all sorts of dramatic steps for on-site working. And some of this, as it relates to CCPA and COVID, it might include the testing and collection of information about the medical conditions of employees and customers, the sharing of information with public health authorities, also responding to government requests for information, and implementing procedures for social distancing and teleworking and working remote. Now, how does this jive with sort of running a next door and asking a colleague about an issue that you've just seen that's a risk and you really want to discuss it. Well, again, all sorts of methods have to now be put in place to make sure that the business as usual handling those risks are being done, as well as what's going on in the world and what's going on in the U.S. A couple of other things. To the extent that your business is considering, again, whether or not to collect or examine information from individuals, again, the employees, the customers, or others, regarding COVID risks, you want to make sure that you're examining your existing policies. So again, we're coming back to the basics. Look at your existing privacy policies to evaluate how they might treat the collection of information relating to a person's medical condition. So you'll want to double, triple check that. And then the last one that I wanted to raise is just looking at whether or not certain exemptions might apply to existing privacy law requirements and how they might cover information and collection of the disclosures. So as an example, if you think about this, many privacy policies allow disclosures to protect persons and property and might also limit disclosures to protect other persons. So in addition, the privacy laws could provide for exemptions of certain disclosures that could also apply in the context of COVID. You know that CCPA does not prevent a company from making disclosures of information that are required by law or in response to civil and criminal or regulatory inquiry, investigation, subpoena, and such. So you'll want to make sure that you're evaluating the key privacy laws that apply to your company, as well as any other requirement and limitation on the collection and use of information. So you want to look at all of this in terms of business as usual and what are then the extra steps you need to take to ensure that you're handling the current pandemic in a correct way for both customers, employees, and any other forces.
Excellent. Jerry, Ron, any thoughts about balancing competing interests in the current climate?
Yeah, this is Ron. Agnes did a great job. Oh, go ahead. Sorry, Jerry, were you jumping in?
No, go ahead.
Go ahead.
No, go ahead, Ron. No, please.
Oh, no, I'm sorry. No, Agnes did a fantastic job covering it, but I would just say, that this obviously this throws a wrinkle into everything that we're doing, and we've had it has been interesting to watch. I think Agnes mentioned earlier the volume. The volume has been very low of requests for CCPA, and with COVID hitting, really across the board in the industry, we've seen a dramatic decrease. So I think that indicates that the consumer focus has shifted elsewhere, but I think we have to be very careful, as Agnes mentioned, that we can't let our guard down in terms of CCPA or any other BAU law and reg, because until we're told that they are not applying in these times, or they're being toned down, or there's different expectations, the way that we're approaching it is every bit as important. The risk to the bank, it may be something to look at in terms of what's the likelihood of enforcement, or what's the volume that you're going to experience. But ultimately, the compliance expectations are there, and we are getting requests. We do expect there to be a lot of attention paid in terms of how we've treated CCPA. So at the end of the day, the coronavirus has thrown a wrench into things, but it has not at all altered our plans for compliance.
So Ron and Agnes covered this waterfront more than fully. I just think it just points up the COVID and the other issues just points up that privacy is not a trump card, but the privacy principles and requirements adhere even in the face of a pandemic, and you've got to think through those. Apply those principles to what you're doing, the information you may be collecting as a result of COVID, as you try to keep your employees safe, as maybe a competing legal requirement. but how long do you keep the data, and what data are you collecting, and how are you thinking about all that? You've got to apply those principles in the context with which you're dealing.
And just to further add to what Ron and Jerry said, this is all important, and people who are managing privacy, even if you get shuttled to the side with other things going on and other focuses because of the pandemic, you still have the obligation to push the agenda on CCPA and privacy and everything else. There are a lot of competing matters, but you still need to raise your hand, bring the issues, because it's business as usual no matter what.
Excellent. Thank you.
Great point.
The panelists for those great points there. I can only add that I think one area where the privacy professional can certainly benefit a lot of these discussions is through making sure that as multiple options for a particular solution might be considered, are you using one that requires perhaps the least data that is necessary? Or where, let's take the example of temperature scanners. If all you really want to do is flag individuals who may be may have a fever, do you necessarily need to know who those individuals are? If you're considering one option that has facial recognition or some other way that may identify the individual, do you need that information or not? Or can you just get by with the fact this person may have a fever or they don't? Because it greatly reduces the privacy burden down the line if you don't necessarily need information that is person identifiable. So with that, let's turn to another aspect of CCPA, which is private litigation. We've seen several lawsuits filed under CCPA by private litigants. What are some of the lessons, themes that we've seen from some of these private lawsuits that have been filed since the beginning of the year? I'll turn to Luke.
Thank you, Jim. So as Jim mentioned, we have, since January 1st, started to see these lawsuits come in. There are 12 or so defendants that have been named in these lawsuits. There are more lawsuits pending, but there are multiple suits against certain of the defendants. So there's more suits than parties at this point. The suits that are all at an early stage, most of them have been filed in federal court in California, either in the central or northern districts. And most of them are still at the stage where the parties are either trying to figure out where the lawsuit should be. The plaintiffs are trying to set themselves up as class counsel. So really not any decisive court orders yet regarding the scope of some of these claims. And that leads me to the second point, which is really we're kind of at an exploratory or a testing phase of some of these claims right now. So the private right of action under the CCPA, as written in the statute, is limited to data breaches. And it's data breaches not of just any personally identifiable data as defined under the CCPA, but a specific type of data, including such things as government-issued identifiers or financial information. So it doesn't even apply, the private right of action doesn't even apply to all of the personal data that a company might collect that would otherwise be subject to the CCPA. The text of the actual private right of action has not stopped plaintiffs' lawyers from bringing claims under theories that don't appear to be permissible to be brought as private claims. Some of the lawsuits include things like notice violations, things like UCL claims. So UCL is California's unfair competition law. There's a specific provision in the CCPA that purports to ban using the statute as a precursor to unfair competition claims. That hasn't stopped plaintiffs' lawyers from some of these lawsuits from trying that out. A number of the lawsuits have also alleged breach of data that's not specifically the type of data that the CCPA contemplates would permit a private right of action. that hasn't deterred some of these folks either. And finally, arbitration. In some of these lawsuits, the consumers, the plaintiffs, are certainly bound by, or arguably bound by, arbitration provisions. There's a separate provision in the CCPA that arguably applies to ban applying arbitration provisions to CCPA claims, at least interpreted very broadly. That hasn't been tested yet. So really the plaintiffs are pushing the boundaries of what the CCPA actually permits in terms of the types of litigation that may be brought, which really means that the next 6 to 12 months is when a lot of these issues are going to be decided. A lot of these folks, a lot of the defendants that are named are going to start bringing motions to dismiss. I would imagine some of them are going to start bringing motions to compel arbitration. And really, in terms of the key takeaway, it's to pay attention, because courts are going to be issuing, and again, this is going to be sometime within a 6 to 12 month time frame, the courts are going to be issuing some very important opinions about the scope of the private right of action. Certainly standing issues might also come up, and companies are really going to need to track what the courts are saying, what theories are surviving, and what theories are not.
Excellent. Okay. Thank you, Luke. With that, I'd like to move on to our last question. So let's just assume very hypothetically that we all had CCPA well in hand. We understood what it meant. We knew how to comply. We still have this new thing on the horizon, the CPRA, brought to you by many of the same people who brought us CCPA in the first place. CPRA is a ballot initiative that purports to have enough signatures to qualify for the ballot in the fall in California. It would certainly strengthen and expand many of the consumer rights and business responsibilities for privacy under CCPA. And so the question then arises, how do we prepare for CCPA when many of the rules may change yet again if we end up with CCPRA? So I would welcome anyone's thoughts on that, particularly maybe Ron would like to start off.
Sure. So I think it's really important for everybody to at least be aware of the CPRA initiative and understand what is included and how it could potentially impact your institution, because there's a lot to it. It goes a lot further than CCPA, and for some companies, it's going to be difficult to try to get ready for this in the time frame that will be available. And I think the biggest challenge from a practical perspective is, you mentioned earlier, Jim, there are a couple of exemptions that would expire and go into effect in 2021, the employee exemption and the business-to-business exemption to the CCPA. If the CPRA passes, we'll have another couple of years to kind of sort through those issues and get ready for that scope. However, if the CPRA does not go through, if it does not pass, as you said, they're going to be in effect next year. So one of the biggest pieces of conversation, as we talk about some of the benchmarking conversations, a lot of companies are really trying to figure out to what extent are we preparing now for these exemptions to be expired and to potentially be going into effect next year. Because, for example, if employees are allowed to make requests under the CCPA, have you figured out what that information is that you have? Have you figured out, are you going to treat those the same as you do consumer requests in terms of the platform and the fulfillment process, or is it going to look to be something different? And have you thought through your exemptions and how they may or may not apply to your particular company? There's just a lot of things that you have to really to at least start thinking about. And so that is probably the number one practical consideration as it relates to the time frame of the CPRA.
Excellent. Thank you. Anyone else have thoughts about CPRA and keeping an eye on it in light of CCPA still coming into being?
So Jim, Ron's points were all spot on. Just a couple of things to think about, that the CPRA, if on the ballot and if passed, will bring about a data protection regulator, not the AG, but an entity focused purely on California privacy rights. There are, as Ron mentioned, the enhancements there. Data retention provisions are more explicit in the CPRA. There are data correction provisions. There are enhanced contractual requirements, audit and risk assessment provisions on the technology side, and reports that appear to be required yearly under the CPRA. The point being, get to the state, Jim, that you mentioned of having your California, the CCPA, California Consumer Privacy Act, under your belt, and your arms around it, because it looks like more is coming.
Well, thanks, Jerry. It's excellent points there. Anyone else have thoughts here? If not, then I think we're at the top of the hour. I think we can close up. I'd like to thank everyone for attending. I'd like to particularly thank our panelists. We have this is an eminently qualified panel of people who've been doing privacy compliance at the highest level for a very long time, and I'm greatly thankful and honored that they joined us today to share their excellent thoughts on these topics. Thank you for attending. Please complete and submit the survey that's located in the widget at the bottom of your screen. Hopefully we'll have more of these. Certainly if there are privacy or other cyber topics you'd like to hear about, or other particular issues under CCPA, let us know. Thank you all again, and have a good day.